Hi there, I'm Jim Foster, Broker Associate with Brokers Guild Real Estate, and in this video we're going to take a look at the exclusive right to sell listing contract, which we'll refer to as the listing agreement. This document can also be thought of as an employment agreement between a seller and the real estate broker they select to list their property for sale. In other words, the broker who will have their sign in the yard or window. My team and I use real estate contract forms that have been approved by the Colorado Real Estate Commission. This listing agreement is a binding contract, and you have the right to consult legal or tax counsel before signing. As defined in the document titled Definitions of Working Relationships, different brokerage relationships are available, which include seller agency, buyer agency, or transaction broker. In the exclusive right to sell listing contract, you can select to have your broker work with you as a seller agent or a transaction broker. As you can see, this document will have the date on which it was prepared for your review. Now we'll go through each of the 35 sections in the listing agreement. Section 1 defines the agreement, which says the broker agrees to provide services and the seller agrees to pay brokerage firm as defined in this listing agreement. Section 2 clarifies if the broker is part of a multiple-person firm or a one-person firm. I'm part of a multiple-person firm. Section 3 defines the terms of this agreement, including the seller name, brokerage firm name, broker name, property, county, legal description, and a street address in 3.1 through 3.4. If the property is subject to an affordable housing program, the box in 3.5 is checked. If the seller also authorizes broker to negotiate a lease, then the box in 3.6.2 is checked. Section 4 talks about the brokerage relationship. 4.1 states that if the seller agency box is checked, then the broker is the seller's limited agent, and if the transaction brokerage box is checked, the broker is a transaction broker. 4.2 explains what happens if the buyer is working with another broker within the same brokerage firm. 4.3 explains what happens if the buyer is working with the same broker as the listing broker. 4.3.1.1 states that the listing broker remains a seller's agent and the buyer will be a customer unless the broker also has a brokerage relationship with the buyer. 4.3.1.2 states that the listing broker will remain a seller's agent and not work with any buyers that the listing broker also has a brokerage relationship with. 4.3.2 states that if the listing broker also has a brokerage relationship with a buyer who is interested in your property, who wants to make an offer on your property, then the listing broker defaults to a transaction broker for both the seller and the buyer. This basically means that the listing broker becomes a neutral broker for both parties relating to the transaction and is obligated to treat each party fairly, honestly, and in a professional manner, but relating to this specific buyer, no agency relationship shall exist with either the seller or the buyer. Section 5 outlines the brokerage duties. 5.1.1 through 5.1.6 lists the minimum uniform duties that the listing broker must exercise reasonable skill and care for the seller. 5.2.1 through 5.2.5 lists all information that the broker must not disclose without the informed consent of the seller. 5.3 states that the seller consents to the listing broker being allowed to disclose confidential information to their managing broker for the purpose of proper supervision, but no one else. 5.4 states that the listing broker may also show buyers other properties for sale and also list other properties for sale in addition to the seller's property. 5.5 states that the listing broker is not obligated to seek additional offers once the property is under contract with the buyer. 5.6 states that the listing broker has no duty to conduct an independent inspection of the property or verify the accuracy of statements made by the seller or independent inspectors. 5.7 states that the seller understands that the seller is not liable for broker's acts or omissions. 5.8, depending on which box is checked, the broker either will or will not disclose to buyers whether or not there are existing offers on the property and if they were obtained within the brokerage firm or another brokerage firm. Section 6 lists the additional duties of seller's agent if the box at the top of page 1 is checked, stating that the listing broker is a seller's agent. Section 7 covers the compensation to the listing brokerage firm and the cooperating broker working with the buyer. 7.1.1 states the total commission, which includes any co-op commission payable to the broker working with the buyer, and it is only due and payable at the time of a successful closing. 7.1.2 covers the lease commission if the property is being marketed for rent. 7.1.3 outlines any other compensation if agreed to between the seller and broker. 7.2.1 through 7.2.3 clarifies when the commission is earned. 7.3 states when the commission is payable, which is typically at the time of closing. Section 8 defines the limitation on third-party compensation. Section 9 covers other broker's assistance, multiple listing services, or MLS, and marketing. 9.1.1 states whether the property will or will not be submitted to one or more MLS systems and will or will not be submitted to one or more property information exchanges. 9.1.2 states that the seller authorizes the use of electronic and all other marketing methods except any listed here. 9.1.3 states that the seller authorizes the use of data by MLS and property information exchanges, if any. 9.1.4 states if the property address will or will not be displayed on the Internet. 9.1.5 states if the property listing will or will not be displayed on the Internet. 9.2 states how brokers may access the property, whether by lockbox or some other method. 9.2.2 states who the seller authorizes to access the property. 9.3.1 in the broker marketing section outlines the specific marketing tasks that will be performed by the broker. 9.3.2 states what videos and pictures of both the interior and exterior that the seller does not authorize to be used. 9.4 states that the broker may discontinue using marketing materials if the broker receives a complaint regarding the use of any marketing materials and will use reasonable efforts to remove said materials from the Internet, although this may be difficult or impossible from syndicators and the Internet itself. Section 10 talks about the seller's obligations to broker, disclosure and consent. 10.1 states that the seller agrees to conduct all negotiations for the sale of the property only through the broker. 10.2 says that the seller agrees that any advertising of the property by the seller must first be approved by the broker. 10.3 states whether or not the seller is or is not currently a party to any listing agreement with any other broker and whether or not the seller has or has not received a list of submitted prospects from a previous listing agreement to sell the property with any other broker. 10.4 says that all materials, including photographs, renderings, images, videos, or other creative items supplied to the broker by the seller are owned by the seller, and seller grants the broker a license to use these items in its marketing efforts, etc. 10.5 covers whether or not the Colorado Foreclosure Protection Act applies to this seller's specific situation, which would mean that in addition to several other requirements, the property is in foreclosure and any loan secured by the property is at least 30 days delinquent or in default. If this is not the case, then the Colorado Foreclosure Protection Act does not apply. Section 11 outlines the price and terms to be offered in the marketing of the property that are acceptable to the seller. 11.1 is the initial listing price. 11.2 states what type of funds or new loan a buyer can use to purchase the property. 11.3 addresses any loan discount points to be paid by the seller in order for a buyer to obtain a lower interest rate on their proposed loan. 11.4 states the maximum amount of any closing costs and fees associated with a buyer's closing costs that are not allowed to be paid by a buyer at closing if the buyer is obtaining an FHA or VA loan. 11.5 states the minimum amount of earnest money deposit that will be requested from a potential buyer and in what form those funds will be provided, which could include a check, a wire transfer, or a promissory note, etc. 11.6 states how the seller wishes to receive their net proceeds at closing, whether in the form of a cashier's check at seller's expense, wire transfer at seller's expense, or the closing company's trust account check at no additional cost. Please take steps to avoid wire and other frauds when supplying confidential information such as bank account numbers and social security numbers, etc. 11.7 requires the seller to disclose if they are a foreign person for purposes of U.S. income taxation pursuant to the Foreign Investment in Real Property Tax Act. 11.8 addresses potential Colorado withholding for out-of-state residents when, if the seller is not exempt, the Colorado Department of Revenue may require a portion of the seller's proceeds be withheld after closing when the seller will not be a Colorado resident after closing. Section 12 covers deposits, such as who will hold the earnest money deposit and how it will be delivered to the closing agent at or before the closing. Section 13 covers the inclusions and exclusions of personal property associated with the sale of the real property that are included in the purchase price. 13.1.1 covers inclusions that are attached, such as lighting, heating, plumbing, mirrors, etc. 13.1.2 covers inclusions that are not attached, such as storm doors, window coverings, storage sheds, etc. 13.1.3 covers other specific items, which could include things like a refrigerator, stove, microwave, washer, dryer, solar panels, water softeners, etc. 13.1.4 states that all inclusions must be conveyed by seller free and clear of all taxes, liens, and encumbrances unless otherwise listed in this section. 13.1.5 states that all personal property will be conveyed by bill of sale or other applicable legal instrument. 13.1.6.1 spells out if there are personal property items that are part of the transaction that are leased, such as solar panels, for example. 13.1.6.2 states that seller agrees to supply buyer with copies of all documents relating to any leased items as agreed to in the purchase contract, such as leased solar panels, for example, if buyer will be assuming any lease at closing. 13.2 spells out any personal property that will be excluded from the sale of the property. If you intend to take something with you, such as an appliance, a light fixture, rose bush, etc., then it needs to be listed here. 13.3 primarily applies to business-related properties where a trade fixture may be included with the sale. 13.4 spells out what parking facilities are included as use only or ownership, if any, and what use or ownership of storage facilities may be included. 13.5.1 lists any legally described water rights to be included and what type of deed they will be conveyed by. 13.5.2 lists any other rights relating to water that may be included. 13.5.3 states the well permit number if there is an existing well on the property. 13.5.4 lists any water stock certificates that may be associated with the property. 13.6 lists any growing crops that may be included in the sale of the property. Section 14 talks about the title and encumbrances. 14.1 states that seller represents that title to the property is solely in the seller's name. 14.2 says that seller must deliver to broker true copies of all relevant title materials, leases, surveys, etc. 14.3 states what type of deed will be used to convey the property. 14.4 lists any existing monetary encumbrances that will have to be paid off so the property can be conveyed free and clear at the closing. 14.5 describes any leases and tenancies that the sale of the property will be subject to at closing, if any. Section 15 states that the seller will furnish the buyer with a current commitment and owner's title insurance policy at seller's expense at closing unless there is a different arrangement agreed to in the purchase contract. Section 16 only applies if the property is located within a homeowner association and states the amount of HOA assessments and the frequency in which they are due. It also clarifies if there are any special assessments associated with the property and that the seller will promptly request a current statement from the HOA. Section 17 explains how the possession of the property will be offered to and delivered to the buyer, subject to any leases and tenancies currently in effect, if any. Section 18 clarifies about material defects, disclosures, and inspection. 18.1 lists the broker's obligations of what material facts are required by law to be disclosed by broker. 18.2.1 states whether the seller agrees or does not agree to provide a seller's property disclosure completed to the seller's current actual knowledge. Colorado law requires that sellers disclose adverse material facts actually known by the seller, regardless of whether a seller is providing a seller's property disclosure form or not. 18.2.2 says that if the original building permit for the property was issued prior to January 1st, 1978, the seller and broker must provide the buyer with a copy of a lead-based paint disclosure. 18.2.3 states that Colorado law requires every seller to provide carbon monoxide detectors within 15 feet of every bedroom door if the property has a fuel-fired heater or appliance, a fireplace, or an attached garage. 18.2.4 states that the property will be conveyed in the condition existing as of the date of the contract, ordinary wear and tear accepted, unless seller agrees to any repairs or other rework performed by the seller. Section 19 clarifies what happens in the event of default and the party's right to cancel. 19.1 covers what happens if the broker is in default. 19.2 covers what happens if the seller is in default. 19.3 spells out additional rights of brokerage firm to cancel. Section 20 clarifies what happens if payments, such as earnest money deposits, are forfeited. Section 21 addresses who is responsible for the cost of services and any authorized reimbursements. Section 22 is a disclosure to seller that costs and services vary between different settlement service providers, such as attorneys, lenders, inspectors, and title companies. Section 23 states that neither the broker or brokerage firm is responsible for maintenance of the property or damage to the property unless the damage is caused by their negligence or intentional misconduct. Section 24 covers nondiscrimination and states that all parties agree not to discriminate unlawfully against any prospective buyers because of their inclusion in a protected class as defined by federal, state, or local laws. Section 25 states that seller acknowledges that broker has advised them they have the right to consult with tax and legal counsel before signing this listing agreement. Section 26 clarifies that if a dispute arises relating to this listing agreement, the parties must first proceed in good faith to submit the matter to mediation. Section 27 addresses who is responsible for attorney and legal fees in the event of any arbitration or litigation relating to this listing agreement. Section 28 is where any additional provisions not already included in this listing agreement can be listed and clarified, if any. Section 29 is where any attachments to this listing agreement can be listed. Section 30 basically says that there are no other parties to this agreement other than the seller, broker, and brokerage firm. Section 31.1 defines what physical delivery and notice means relating to this listing agreement. 31.2 defines what electronic notice means relating to this listing agreement. 31.3 defines what electronic delivery means relating to this listing agreement. 31.4 says that this listing agreement and any disputes that may arise are governed by and construed in accordance with the laws of Colorado. Section 32 states that any modification of this listing agreement must be in writing and signed by all parties. Section 33 states that this listing agreement may be executed by each of the parties separately, and when so executed by all parties, such copies taken together are deemed to be a full and complete contract between the parties. Section 34 states that this agreement constitutes the entire contract between the parties, and any prior agreements, whether oral or written, have been merged into and integrated into this listing agreement. Section 35 states that seller acknowledges receipt of a copy of this listing agreement signed by broker, including all attachments. The last section of the listing agreement is where the sellers and listing brokers sign and date and provide their contact information. Thank you for taking the time to review each section of this listing agreement document, and let us know if you have any questions before signing. When signing a CTM e-contract document, please follow these electronic signing instructions. To sign the document electronically, please click on the blue link and not the PDF in order to open the electronic document to be signed. The contract document will open on your device, which is enabled for signing. Scroll down to the box associated with your name near the bottom of the document. Click on Select Signature Font below your signature box, and your name will appear in the signature box. Click on Save at the lower left corner of the signature box. A pop-up window box will appear asking if you want to accept or decline the signature. Click on Accept to confirm and save your signature on the document. The date will be inserted automatically. You must complete this step for the signature to be saved on the document. Only sign the box associated with your name and not any of the other signature boxes on the document. That's it. All done. Thank you, and we look forward to providing you with excellent service.